The Supreme Court, quote, misunderstands the assignment and is doing back of the napkin assessments about key issues, about people's personal dignity. Those are not my words. Those are the words of Ketanji Brown Jackson, who in a scathing dissent has rejected the majority's decision to allow transgender people to be trolled and dehumanized by Donald Trump and the Trump administration, forcing them to list their gender assigned at birth on their passports, reversing 33 years of policy across 5 or 6 different presidents that allowed people to self-identify for their passports and not be accused of using a false passport that's inconsistent with their identity. Ketanji Brown Jackson wrote a 13-page dissent in opposition to a 1-paragraph emergency docket decision. Here we go again with the emergency dockets and trying to get and speak to the right side of history, as she often does. I'm Michael Popok. You're on Legal AF on Friday. This is important. This is not just important for people who are transgender. This is important for all Americans. And to see what the United States Supreme Court is doing to enable Donald Trump, his immorality and depravity. Here's what she says in a footnote on page 8. Not only does the court stay, meaning they blocked the First Circuit's decision to stop the Trump policy of requiring gender assigned at birth to be reflected on a passport that is only supposed to be concerned with identity and nationality. A person's identity is tied to how they see themselves, how they live their life, not to what some doctor did on the birthday to write a birth certificate. Here's what she says. Not only does the court's stay determination produce inequity, but is also part of a broader pattern of this court using its emergency docket to cavalierly pick the winners and losers in cases that are still pending in the lower courts. This way of handling stay determinations jeopardizes procedural fairness, as well as because the lower courts have an obligation to fully and fairly consider the merits of the plaintiff's legal claims, despite the majority's declaration of the likely winner. The court's stay-related pronouncements cannot be permitted to thwart the full legal process that our judicial system requires. What's she talking about? There's 2 different paths to get to the United States Supreme Court. You can have a traditional writ of certiorari, asking that your case be considered by the United States Supreme Court on full briefing, meaning 3 briefs, maybe some friends of the court briefs, oral argument, and then a written decision of dozens and dozens of pages. That's how 60 or 70 cases get up to the United States Supreme Court from the many thousands below. The Supreme Court meets in a conference, they go through a list, and they decide if there's 4 votes to take on a case. And of course, you need 5 votes to prevail in your case. That's one way. Second way up the mountain is through an emergency docket, a shadow docket, where the Trump administration, time and time again, dozens of times, has filed an emergency application. It comes up through an associate justice, in this case, Ketanji Brown Jackson, who sits over the First Circuit Court of Appeals. It gets generally referred to the full en banc, all 9 of the Supreme Court. And then on a skeletal record, a short-circuited process with just 2 briefs and no oral argument, they issue a 1-paragraph decision, always claiming this is not on the merits when it is on the merits. And then reversing and turning upside down the lives of people. Now, Donald Trump continues to exploit the shadow docket, which he's done from almost day 1 in office. It's part of his playbook. And he's winning there. He's losing at the trial court level, 90%. He's losing at the first level appeal level, 90%, in these hundreds and hundreds and hundreds of cases that are pending against the Trump administration. There were 7 different bad decisions against him just this past week. But at the Supreme Court, on the emergency docket, he's winning 83% of the time, and he knows it. And Ketanji Brown Jackson knows it. Let me read to you what else she says. Now, again, to step back for a moment, this is about sex markers on a passport. Not your name, not your country, not your photo, the checkbox for sex. And for 33 years, people were allowed to have that aligned with their identity as transgender. At some point, they needed a doctor's note. Then they changed that. And then Joe Biden's administration said, it's who, you can self-identify as X, non-binary. You can list that as well. Who is this harming? And what the plaintiffs have said in the case is that this is an attempt by Donald Trump based on his public pronouncements and his executive orders to decree that there are only two sexes. This is what the executive order said. Executive Order 14168, which was actually issued on Inauguration Day, said that transgender identity is false and corrosive to American society, and it asserted that the policy of the United States is to recognize two sexes, male and female, as that was assigned at conception. And then the State Department made its change 2 days later. That's how we got here. Here's what Ketanji Brown Jackson says in her attempt to protect the transgender community. First, she questions how urgent this possibly could be and why it needed a stay, because the State Department has said that the passport policy allowing transgender Americans to have sex markers about their current identity can be used until they expire. Well, how important is it? See, the majority, led by, of course, John Roberts and the MAGA 6, said this is all about foreign affairs. It's always about, whenever they want to give the president a tremendous amount, and Trump particularly, a tremendous amount of power, they say it's foreign affairs. It's official documents that face foreign countries. Here we go. Foreign affairs. It's how, the president gets to dictate, particularly how the foreign-facing documentation for America looks. So they say. Hold that thought, by the way, because we're waiting to see what they're going to do with the tariffs. And there was a lot of argument by John Sauer on behalf of the government about foreign affairs, foreign-facing. And that's the reason, because he knows the Supreme Court has a thing for giving Donald Trump a lot of power in the foreign affairs area. So they say that the district court's grant of class-wide relief and the First Circuit enjoining an executive branch policy with foreign affairs implications concerning documents, it's more likely than not that they're going to win, and that the Trump side is irreparably harmed because they don't get to dictate what their foreign-facing documents look like in America. Ketanji Brown Jackson calls that a back-of-the-napkin assessment that has no place in our federal jurisprudence. The court, she says on page 3, the court ignores these critical limits on its equitable discretion. The government seeks to enforce a questionably legal policy, but it offers no evidence that it will suffer any injury, as opposed to the vulnerable party, the transgender people, who are subject to violence every day, including at the airport. She says such senseless sidestepping of the obvious equitable outcome has become an unfortunate pattern. So too has my own refusal to look the other way when basic principles are selectively discarded. This court has once again paved the way for the immediate infliction of injury without adequate or really any justification. I respectfully dissent. On the issue of the equitable scale, she said it sides with the people who are transgender. She said on page 11, for their part, and by contrast, the plaintiffs have shown they will suffer concrete injuries if the government's passport policy is immediately enforced. Namely, they will be unable to obtain passports with sex markers that match their gender identity. The district court found that this is a significant harm, noting that transgender people who encounter obstacles of obtaining gender-congruent identity documents are almost twice as likely to experience suicidal ideation and report more severe psychological distress than transgender people who do not face such barriers. In addition, the current record demonstrates that transgender people who use gender-incongruent passports are exposed to increased violence, harassment, and discrimination. One of the plaintiffs, A.C. Goldberg, who is transgender and intersex, asserts that he has been sexually assaulted by TSA officers conducting searches on his body. Another plaintiff, Chastain Anderson, attests to having been strip searched when traveling with identity documents that do not match her current gender expression. Another, Zaya Persian has been subjected to invasive pat-downs by TSA agents to confirm her gender after they observed the disjunction between her female gender expression and the male sex marker on her passport. And two others, Ashton Orr and Ray Gorland, have been accused of presenting fake identity documents and were forced to out themselves as transgender and non-binary to TSA agents. This is stressful and invasive for travelers to begin with. She ends her dissent, by saying, in my view, the court's failure to acknowledge the basic norms of equity is more than merely regrettable. It is an abdication of the court's duty to ensure that equitable standards apply equally to all litigants, to transgender people, and the government alike. As we've said before, Ketanji Brown Jackson's scorching dissents, of which she's written about 8 or 9 already, are important because it is our hope that she is speaking to law students, she is speaking to litigants, she has different audiences. She is speaking to history, and she is speaking to a community, the transgender community, that knows they have an advocate and a protector on the United States Supreme Court. She may be in the minority now on this decision, 6-3, but over time, the hope is she will convince the hearts and minds of people on the Supreme Court and move this back to a normal, moral, ethical society. That's what she's preaching about. That's what she's spilling tea about. And we appreciate her. And we appreciate the voice that she brings. She's the youngest on the Supreme Court. She's the boldest. She is willing to take on the institutional and MAGA 6 on the Supreme Court on a regular basis. And we applaud her for that here on Legal AF. Take a moment. I'll post for you in Legal AF Substack today this scathing dissent, scorching dissent for you to read. Consider becoming a paid member of Legal AF Substack. That's what keeps us on the air. That's what pays for our reporting and our honest commentary. It's $6.77 a month. Become a paid member on Legal AF Substack. Legal AF YouTube, we're well on our way to 1 million subscribers. We just crossed about 920,000, and we're going to cross 1 million hopefully by Thanksgiving, beginning of Christmas, somewhere in there with your help. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states, and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.